SJC 13667, Commonwealth versus Michael P. McCarthy.
Okay. Attorney Johnson, whenever you're ready.
Thank you, and may it please the court. Good morning. My name is Melissa Johnson. I'm a Special Assistant District Attorney in Middlesex County here on behalf of the Commonwealth. And I'm asking today for this court to reverse the motion to suppress judge's ruling here, because the detective, our Lowell detective, did everything that was right, everything that was reasonable, everything that was constitutional in this case. As the motion judge found, the seizure of the phone here was based on probable cause and exigent circumstances. In fact, the defendant was destroying evidence on his phone right in front of the detective's face.
It'd be, if we had the good faith exception that New Hampshire does, that'd be a better argument, I think. But let me ask you, if we can short circuit this and get to inevitable discovery, then we don't have to deal with the messy choice of law issue. And the problem I've got with that argument, as attractive as it may be, is I think you're right that the New Hampshire police officer certainly had probable cause to arrest this person for destroying evidence in the officer's presence. But we have two problems. One is we have no testimony by the New Hampshire police officer below, and it doesn't seem like it was a theory the Commonwealth was working on below. And then secondly, and probably more, well, not probably, but equally problematic, is we have a finding by the judge that there would have been no arrest by the New Hampshire police officer. So how do you get around the fact that there's no testimony by the New Hampshire police officer and this finding by the judge for inevitable discovery?
Respectfully, Your Honor, I think we're going way far ahead here, because it's important to me and to the Commonwealth that this court understand that what the detective did here was right.
Okay, before we get to that, could you answer my question?
I do believe, Your Honor, that the fact that there was probable cause to search that phone, that it was going to be searched anyway. This officer seized it and obtained a warrant. Whether he'd done it then because a defendant was actually destroying evidence, or whether he did it later, I don't think it really matters. It's not an.
If I go to New Hampshire, I can't just seize somebody's phone.
Yeah, so.
Can you just seize someone's phone?
Yeah, I
as
don't
an
think
officer?
I can. No way. Yeah, as an officer, as a citizen, which is what this officer was in New Hampshire.
If you, as an officer, had probable cause and you had evidence that the person was destroying it right in front of your face, yes, absolutely, as a private citizen.
Well, you're mixing apples and oranges. You're relying on the status of the police officer extraterritorially to be a private citizen, make a citizen's arrest.
Right.
So, all right, I'm going to go back to my original question, if you could answer it. Are you abandoning the inevitable discovery argument based upon the potential of an arrest by the police officer in New Hampshire?
I'm not abandoning it at all, but I don't think we even need to get there. I do think that we were going to search this phone no matter what, whether we would have seized it under exigent circumstances or whether we would have applied for a warrant at some other time. It was going to be searched. This was a joint venture.
Who is the we in your answer?
We meaning the Massachusetts detectives.
So you're relying on inevitable disclosure by the Massachusetts police?
Yes. But even before we get there, it is important to the Commonwealth that this panel understands what the officer did here, what the detective did here, whether we're talking New Hampshire law or whether we're talking Massachusetts law. And I do believe New Hampshire controls. It doesn't matter. Either way, we get to the same result. This detective here had the authority to seize that phone as a private citizen.
Do we have to agree with you that the judge's findings that it wasn't a coordinated activity? I mean, the judge finds a lot of coordination, but then concludes it's not a joint, I can't remember the exact term of art, it's not a joint operation or whatever.
Right.
Do we find that as are we going to reverse him on that? Is that what you're saying? Do we have to reverse his fact finding on that, or his conclusions of law based on his fact finding?
I think that's part of it, but I don't think it's absolutely necessary. The motion judge relied very heavily on the Luna case here. And I think, to be honest with Your Honor, I spent a lot of time in my briefing distinguishing that case based on the fact that there was involvement and there was the presence of the Nashua PD here. And so on that ground, but honestly, I think Luna is much more narrow than what the motion judge gave it credit for. Because in that case, first of all, the Commonwealth didn't raise the issue as if the Springfield PD was acting as private citizens. But if you think about it, in that case, Springfield PD actually full-on searched the car, which was actually in the driveway, so there was issues with the search in and of itself. I wonder if Springfield PD had just seized the car, as our officer did in this case, and then applied for a warrant, whether we would have been talking about the Chicopee PD being present there at all. And I think that's the issue. They never kind of discussed that angle of it. They didn't talk about the private citizen.
The other states' police officers aren't even there, right?
They're not even there. And here, our officer, our detectives actually contacted Nashua PD. They did everything right. Not that I think it's required. I do think it's best practice, because you never know how these things...
Can you explain to me your answer to Justice Wendlandt about how a private citizen can see someone's evidence?
Mm-hmm. Well, Your Honor, I do believe that we know that private citizens do have the power of arrest on probable cause of felony. So it just seems to be common sense that anything that's less intrusive of that should also be encompassed by that power of a private citizen.
What's the case that says that?
We do have a small body of law. We have Lamone, we have La Riviere, and we have Claiborne, all of which I've cited in my brief, where there's a little bit less intrusive activities that are still encompassed by that private citizen kind of authority. For example, in Lamone, the officer was a Somerville officer off duty who had seen someone drinking and driving, so it was a misdemeanor, so he doesn't quite have that kind of power of arrest. However, this court had found, like, look, he can do minimally intrusive things.
But we were very clear there that he was not acting in an investigatory capacity, which is the opposite here, and it was for public safety, and he just asked the guy, please stay here, like, and don't move. And this is very, very different.
I don't think it's that different. I agree there was a public safety issue here, but here we have someone who is destroying evidence right in front of the detective's face. What is he supposed to do? What if that were, for example, if he was investigating a homicide and the guy has a bloody knife in his pocket and he's about to throw it into the Merrimack River? Is that officer or a private citizen supposed to just stand there and let that happen? So I think that there's an immediacy, there's an
So you're
agency.
relying on common sense extension. There's no law out there. Is that what you're saying?
It is a common sense. I mean, we all...
But no legal authority that you can point to.
It is private citizens, the authority of a private citizen to do anything really that is reasonable and constitutional
To investigate a crime.
up into the moment of arrest. Sure, if you think about it, arrest is highly intrusive.
Don't you have a much
intrusive.
better argument that it's a coordinated investigation? I mean, you're pushing the citizen's arrest thing in a way that you really don't want to go there, do you?
Well, Your Honor, that's an excellent point, except for, and I agree, this case is completely different from Luna because we have the presence and involvement, but I'm not just standing here for this case. I am standing here for the authority of all of our detectives who are investigating a case within our own jurisdiction or in their jurisdiction, to be able to go outside of their jurisdiction and interview witnesses. And if by chance something happens in front of their face, they should have the ability to address it reasonably and constitutionally without the other
So the
host
authority of officers,
being there.
The authority of officers under the rule you're proposing would be nationwide.
It would be wherever the officer is going outside of his jurisdiction to investigate a crime, which happens every single day, to interview witnesses. If something is happening in terms of destruction of evidence right in front of
So
their
the basic
face.
rule about the limited jurisdiction of officers you're suggesting should be changed so that officers can investigate wherever the evidence takes them without having to reach out to the local authorities to coordinate an investigation.
I always think it's good practice to reach out to local authorities because you
No, but
never
as
know.
a constitutional motion to suppress matter, you're saying it's not necessary, that the
Not
rule should
necessary.
be nationwide jurisdiction for any evidentiary investigation.
And I apologize for interrupting you, Your Honor. It's a pretty straightforward formula that is not going to change. Number one, if a detective is acting outside of his jurisdiction, you ask, number one, is there a statute that applies? And we have a handful of statutes here, mutual aid agreements, fresh and continued pursuit. If that doesn't apply, then we go to, okay, is there a common law, private citizens authority there? And we know also that that is very limited to felony, probable cause to believe that there's a felony. And we do have a little bit of wiggle room. If it is a misdemeanor, you can do some less intrusive things. But you go to that.
But just to stop you at the felony,
Right.
it's the authority to arrest as a citizen
Right.
would have, right?
It is the authority to arrest, but we have seen that in the past being applied in other situations, like I said, Lamone, Claiborne, and La Riviere, where it is a little bit less intrusive there. And you,
If it's a common law citizen's arrest
yes, Your Honor.
for a felony, isn't there a requirement that the citizen making the arrest witness the felony?
Well, in Massachusetts, it's actually a probable cause standard.
Okay, but-
We've relaxed a little bit with officers. We don't have a body of law in New Hampshire that addresses it. I think it's reasonably believed that a felony has occurred. And here, it was happening right in front of his face, so I don't think we have an issue here necessarily.
Oh, so you're not relying on the home invasion, you're relying, as the felony, you're relying on the destruction of the evidence?
I think it's both, but it's certainly the destruction of the evidence that's happening right in front of his face, and that's a felony both in New Hampshire and in
There was
Massachusetts.
no arrest here, right?
What's that?
There was no arrest.
There is no arrest, Your
So
Honor.
had he grabbed this person, arrested him, then we'd have a search instance arrest and we'd be good to go.
Yes, we would. And so it's just, to me, I cannot make sense of the fact that that intrusive in an action is allowable in this situation, and yet something that is less intrusive, that an officer is simply trying to address an exigent circumstance where he has probable cause to do so, that he cannot do that. It just, I can't wrap my head around that, honestly.
Can I ask you one question that follows up on Justice Kafker's question?
Yes, Your Honor.
If we're talking about the coordinated effort, doesn't the term coordination bake in some kind of active participation? I mean, when we use coordinated, I think the common sense proposition is that everybody's rowing in the same direction. We're not having a situation like we have here, where the New Hampshire authorities are just there. They're just on scene. They're not doing anything. They're not participating. They're not asking any questions. They're not doing any part of the investigation. They're not doing anything.
Well, I wouldn't say
So
they're not.
where's the coordination other than just being there?
Well, first of all, I think without Nashua PD, they would not have found the defendant. Obviously, they were coordinating with him and trying to locate this defendant. They knew his address. He had a very long history with Nashua PD. They were familiar with him. They were familiar with the girlfriend, who basically told them where the defendant was, and the girlfriend had also corroborated the fact that the defendant had used her car to travel with the co-D to Lowell.
They wouldn't have known about the girlfriend, but for the Nashua police.
Exactly. But I don't want to go down that path necessarily, because how
And
do
they
you
see
measure?
the Massachusetts officer asked the New Hampshire officer, did he just delete
Yes.
some text? And the New Hampshire says, yeah, he just deleted the text.
And he confirmed that. So, but I don't necessarily want to
But
go
are you waiving that argument then, that the judges finding that there was not coordination between Nashua in Lowell was clearly erroneous.
I am not waiving it. I do think it was
So can you just
clearly-
walk me through your argument that it was clearly erroneous?
I think it's clearly erroneous because he was basing his finding on Luna, the fact that Chicopee PD was not present. My point was not only were they present, they were instrumental in our detectives finding these defendants.
You don't need to have it clearly erroneous. If we can agree with all his fact-finding and reject his conclusion of law that they weren't coordinating, can't we?
I agree, and that's my point is that it's
By the way,
the authority of the.
Do you want to spend at least a minute on the issue we took, which is whose law applies?
Sure. May I just finish the authority of the detective doesn't necessarily stem from the fact that Nashua PD was present. It stems from his ability as a private citizen, an officer acting as a private citizen, acting constitutionally.
But again, you're merging two doctrines there. How about your
I'm
best
trying to
chance of
harmonize
winning
them.
is that the New Hampshire law applies. You want to take a shot at that for a minute or two?
Your Honor, Gulick was decided 42 years ago. It's never been overruled. It says that the locus of the arrest is where the law has been.
There's no arrest.
It's the arrest, however, that has been applied in situations where there was a search in our house, where there was a seizure in Camara, where there was a stop in Savage. All of those applied that kind of Gulick where it happens. And if you think about it logically.
We have arrest cases, which this isn't, that say that it's the place of the arrest. But then we have all the other cases where we basically didn't have to decide the issue because the law was equivalent.
Right. Your Honor.
Which seems like the law's certainly not equivalent here. 'Cause
Well,
it's a big difference between the New Hampshire law and the remedy in the good faith exception versus Massachusetts law, right?
Okay, I have two answers to that. Number one, I don't think there was anything wrong here in either sets of law, and I think the remedy in terms of what the end result is the same, Your Honor, because even if there was no exclusionary rule, as there is in New Hampshire, we know that obviously it won't get suppressed, but even in Massachusetts, our common law rule of exclusion, it's not automatic. It's not required. It has to be a substantial violation. If you think about the deterrent is, to prevent the abuse of official power. Where is the misconduct here? What are we deterring when we have an officer who's acting in an exigent circumstance to prevent the destruction of evidence? So even if we talk about the common law of exclusion that we have here in Massachusetts, it's still not going to apply to this situation. Just like in Coburn and just like in Leahy, where they said, look, this is not substantial. It's not going to deter future official misconduct. I even question whether there was misconduct at all, and there wasn't misconduct here. This officer was acting reasonably. He was acting constitutionally in an exigent situation.
Can I ask a legal, so the case that you're relying on, again, as Justice Gaziano points out, is an arrest case.
Right.
Are there search cases? Because you would think that the place of the search would be important when we're dealing with, an Article 14 or the New Hampshire equivalent of Article 14 or the
Yes,
Fourth
Your
Amendment.
Honor.
Do we have no
There is-
cases saying that the choice of law is for a motion to suppress is the location of the search?
Yes, I cited one in my brief, Our
case is
House. That's Our House, AARHUS at 387 Mass.
And that's a criminal case,
735.
not a civil case?
It is a criminal case. It was a case where this court had applied military law. A search happened on a military reservation, and even though we prosecuted the murder in our superior court, it applied military law in terms of deciding whether the search was reasonable. Also, the appeals court in Camara talked about applying Rhode Island law to the seizure of a car. Again, like here, it was just a seizure, it was not a search. So in that case, yes, we have applied it. And if you think about it, if we're going to apply it when it comes time, when it's an arrest in a certain location, it doesn't make logical sense to not apply it when you're talking about actions that are leading up to arrest or tantamount to arrest or somehow around that arrest, to somehow apply another law for that, but yet at the moment of arrest, you're going to apply the state where it happened. That just doesn't make logical sense. It all should be the same body of law.
But in our house, that was just the question of whether the search was reasonable. They didn't reach the question of if it was unreasonable, would suppression, whose law would apply to suppression?
No, and I think that they probably go hand in hand. I don't know if you could divide it.
The remedy would seem to me, right, and it's an evidentiary rule. And do we have choice of law that says, any choice of law that says we apply the evidentiary rules of a jurisdiction other than the jurisdiction in which the trial is taking place?
You know, I've thought about this, Your Honor, but if you're going to decide that a search is not reasonable, and if you're saying that the exclusionary rule is there to deter that unreasonable conduct, then they kind of have to go hand in hand. So if you're going to look at...
But my question was a little different.
Okay.
My question actually asked for some law on whether we have any cases that say that you apply a different jurisdiction's law in determining what evidence is admissible when the trial is occurring in a particular jurisdiction. The jurisdiction where the trial is taking place would apply another jurisdiction's evidentiary rules.
I'm not aware of any criminal case, and that is the reason because we have a constitution, we have an exclusionary rule that's trying to deter official misconduct. There may be civil cases that I'm unaware of, but in criminal cases, I believe it goes hand in hand, but I am not aware of it.
And then Kumar, I just looked it up. It's a 128, and it doesn't do what you say. It's a toss-up. It says the law is the same in Rhode Island and in Massachusetts, so it doesn't decide the issue. So we really have no cases except for this military reservation case.
Right, Your Honor. That was just another example. I think the only difference really is that remedy, which is in New Hampshire, we don't suppress where it's a constitutional non-violation. But in Massachusetts, we do have this common law exclusionary rule. And as I explained, number one, I don't think there was any misconduct here whatsoever. And number two, it's certainly not one that's substantial or that would deter future misconduct on the part of this detective or any detective. And for that reason, I think we get to the same result.
Okay.
If there are any further questions, I'd ask this court to reverse the motion judge's ruling. Thank you.
Thank you. Okay, Attorney Schneiderman.
Good morning. Good morning. May it please the court. I am Joseph Schneiderman. I represent Michael McCarthy. I'd like to start by answering a few questions that I think went unanswered by my sister. First, Justice Wolahogian, you had asked about the state of the law on choice of law. The closest that I have to your question is the Cosme case in 417 Mass, talking about how remedies are procedural in nature and how a Massachusetts court would apply Massachusetts remedies to a case pending in a Massachusetts court. Justice Gaziano and Justice Wendland had asked my sister about why this is a citizen's arrest and the legal significance of it as a citizen's arrest. The problem with a citizen's arrest argument, as I see it, is even though there is probable cause, and Justice Wolahogian, you had asked my sister a minute ago about what the standard is, and Claiborne does relax that standard, there just is not an arrest that occurred here. Detective Bowler seizes the phone of his own initiative and volition. That's at Suppression Hearing, Volume 1, page 30. No, there was no arrest here. So the problem with couching this in terms of a citizen's arrest or as a valid seizure incident to a citizen's arrest is that there is no arrest, and this court and the appeals court have rejected that there is such a concept as search incident to probable cause to arrest. The appeals court rejected that. Your Honor.
Could the defendant have been arrested by the Lowell officer? Could he have been?
No, Your Honor. The Lowell officer, we wouldn't be here, actually, Your Honor, if Officer Zuposki had said, get Mr. McCarthy or grab that phone. If the record bore that out, as Justice Gaziano pointed to, if the national officers had testified and if the record reflected that Officer Zuposki or one of the other national officers said, get that phone or arrest that man, we wouldn't be here.
No. What if he
I'm
was
sorry.
by himself? The Lowell officer was by himself. Could he have arrested the defendant as a citizen?
I suppose he could have arrested.
Yeah, so I think the Commonwealth's argument, as I understand it, is that given that he could have arrested the defendant, doing something short of arresting him, seizing the phone when he's destroying the evidence, makes a lot of common sense. Can you just address that?
Your Honor, I would agree that it would make perhaps some common sense, but the problem is that the rule in Massachusetts is that an officer only has authority in their municipality of appointment. The Commonwealth, therefore, would have to show that an exception applies. And there just isn't an exception that applies on this record, and it actually goes to something that Justice Kafker was asking, which are the facts. The facts here do not reflect coordination, and Justice George had asked about this, as a matter of fact or law. The motion judge makes an express finding that although the national officers were present, they were passive. Passive presence of law enforcement officers should not constitute coordination as a matter of law.
Hey, Mr. Steinman, you get very excited, so a little softer.
Of course.
But they are doing more than just being present, right?
Mm-hmm.
They're driving, they're taking him to the place, they're identifying the girlfriend, they're
Mm-hmm.
identifying the deletion of texts. Yes, there's not an official appointment where they're joint officers working together, but it's a practical matter. As your sister just argued, the Massachusetts police are doing everything correctly. Maybe not at the end they aren't, but they're speaking to them, they're working together, they're not, showing up in some other state and, flashing a badge that's not applicable. They're behaving appropriately. Why isn't that really coordination in a practical sense?
Your Honor, I think actually the case law or the ancestry shows that the question of what officer acts is the tip of whether or not there is legally valid coordination. So agreeing with Your Honor that there is an effort here between the Nashua and the Lowell officers, the legal question or the nub of it is who actually acted, and here it was Detective Bowler.
Are there cases that can provide us good guidance on how official I understand the judge finds no coordination, but that's a legal conclusion. He makes facts finding that we have to defer to, but are there cases that tell us about what is adequate for coordination in terms of extraterritorial operations?
Your Honor, I think Morrissey is an example of that, because in Morrissey, the officer in charge of the Sterling Police Department asked the West Boylston officer to engage. I think Lamone actually might speak to that, because the Somerville officer, he was in uniform, but he waited for the Woburn officer. So I think that goes to my point, which is that coordination, the end result of the coordination is what matters and what legally or validates or invalidates the seizure.
If we assume for a second we disagree with you and disagree with the finding by the judge of a joint investigation, then we go to, I guess, the menu of all those cases we've ignored in the footnote to Justice Spina's case, where he says, here's the three options, and we look at the law review article you submitted as well. If we were looking at this as the majority of states do on the exclusionary rule, right, focused, don't you lose? Because to me, I think as counsel pointed out, opposing counsel pointed out, there's really nothing that this police officer did wrong. It's just a question of who was closest to this person to seize the phone. So don't you lose under that analysis, under exclusionary rule analysis for choice of law, or even police officer focused, as the law review article suggests?
I think, Your Honor, under either, actually, I would win, whether it's the exclusionary rule or indeed it is the identity of the officer, because this is actually something I wanted to respond to. New Hampshire would not recognize a good faith exception on these facts. At page 56 and 71 of my brief, New Hampshire recognizes a good faith exception only to the extent an officer relies on an ordinance or a statute to conduct some action. We don't have that here. We don't have Detective Bowler relying on some statute to do that. So there's no good faith exception that applies on these facts. More to Your Honor's question about the core purposes of suppression, we have the intractable collision, though, of the remedies of suppression here. And given that this court has recognized consistently for a very long time that the remedy for an officer who exceeds their territorial boundaries is suppression, I think a theory of suppression becomes compelling here because a Massachusetts court is very well suited to deter misconduct by a Massachusetts officer wherever it occurs, because parties have the right, and this actually goes a little bit to what Justice Wolahogian was asking about, to rely on and have expectations of the forum. And Massachusetts is the forum here. Mr. McCarthy stands indicted in the Middlesex Superior Court for a crime that occurred in Lowell. He just happens to live in New Hampshire.
But the search that you contest is illegal and unconstitutional takes place in New Hampshire. Doesn't the fact that the unconstitutional conduct that we're dealing with is in New Hampshire more important than where the trial is going to take place? And I just don't understand why an arrest is governed by the location and the search wouldn't, even though in the arrest is a prosecution is taking place in Massachusetts, but the arrest is in another state. And the same thing here, the prosecution is in Massachusetts, but the search is in another state. Why would you treat searches different than arrests?
Your Honor, I think searches and arrests actually should be treated similarly, and this court has not had occasion to consider.
But then don't you lose if we treat searches like arrests, because the Gullickson case, whatever that case is a Gullick case is 50 years old at this point, and it says we look at the arrest, the location of the arrest. Your brief was terrific, except for it doesn't confront Gullick.
Your Honor, I'll confront Gullick now then. Yeah. Your Honor, Gullick, as far as I could tell from Gullick, there was not an intractable legal collision here, which is what we have on this record. Massachusetts presumptively recognizes suppression when an officer acts outside of their city or town. New Hampshire does not, State versus Smith. Gullick, there was no need to reach that question. Prior cases following Gullick, like our house or the North Carolina case in 63 Mass Ap, I don't remember the defendant's name, there was no intractable collision. Here we have an intractable collision, and indeed an intractable collision that influences the ultimate result. And because we have that intractable collision, the site of the action cannot and should not be the only thing that governs. That would be inconsistent with how a few years after Gullick and Bushkin, this court recognized we don't believe in lex loci, law of the place, anymore. So I think to say that the site of the arrest or the seizure is a keystone card or is the only thing that matters ignores development. So Banville is factually distinguishable, and Banville does not account for Bushkin and Bushkin's progeny.
Would you agree with me that if we decide it's a joint investigation, the place of the search governs on choice of law?
I'm not sure I've fully. Could I ask more about that, Your Honor, please?
So, as I read the treatise and I look at the cases on choice of law, it seems to say whether exclusionary rule or police officer focus, it does say if it's a joint investigation, the place where the investigation occurs is the law we apply. Do you agree with that?
having heard it that way, Your Honor, I would tend to agree with that.
All right, I'll ask better questions next time.
Oh, no, Your Honor.
I don't promise, but
I'm
I'll
here to
try.
help you, Your Honor,
Thank you.
so.
Could I ask
I
you-
need
There
help.
was a joint investigation by Nashua and Lowell. Then those Nashua officers would have had probable cause, just like the Lowell officers did, to seize the phone, right? So the question really is not so much whether Massachusetts or New Hampshire law applies and whether it's the locus. It's really about whether that probable cause that existed to seize the phone, whether the officers get the benefit of that because they were coordinating with the New Hampshire officers.
I think, Your Honor, if we were looking at it through that lens of a transfer of probable cause, which New Hampshire does recognize, I did brief that. The problem is that, again, we just don't have an arrest to validate the seizure. And as Justice Gaziano was
No,
asking
but
my
the
sister.
New
I'm
Hampshire
sorry.
officers didn't have to arrest the defendant. They could have seized the phone.
That's correct, Your Honor, yes. That I agree with. The problem is that we just don't have an arrest to validate that.
Can I go back to Justice Gaziano's question?
Sure.
So you seem to concede that if it were a joint investigation, the law of wherever the event took place would govern. Do you make the same concession with respect to the remedy? So if, to put a finer point on it, what if there's a joint investigation, the officers engage in some sort of unconstitutional, it's a New Hampshire, Massachusetts joint investigation, they engage in some sort of misconduct here in Massachusetts, you know, the New Hampshire court, then does the New Hampshire court provide suppression even though there wouldn't be suppression under New Hampshire law usually because it happened here in Massachusetts, and then similarly, you know, we have the opposite here?
I had not thought about it in that granular of terms, Your Honor, but I think the rub of relying on the locus just in a vacuum is that it does not account for who's using that evidence, and it would not account for the core purposes of suppression. So I think in Your Honor's hypothetical, which turns the facts around to say it's New Hampshire, but it's coming into Massachusetts, I think then the Massachusetts court would be in just as awkward a position as a New Hampshire court would be trying to deter misconduct by someone who's out of state. So I see I'm running out of time. I just would make two very brief points, which is this whole scenario is the rule that Detective Bowler does not have authority outside of Lowell, and the Commonwealth is trying to box themselves into an exception, and I don't think the record bears that out, and I think to infer coordination factually or legally is a stretch or would be impermissible fact findings. And very briefly about inevitable discovery, we just don't have a record here that bears out inevitable discovery because the Nashua officers did not testify, and there was no testimony other than the fact that we got a warrant, and that's not enough. Unless Your Honors have further questions, I thank you for your time.